let's go ahead and knock this last part out. You'll notice we're up to the 1910, 1930 courts, and just a couple of things on here as we deal with this. Number one, you got this idea up here of checks and balances. And just to stress this for just a second, the idea basically is that the Supreme Court is the highest court in the land, and in theory, they're going to have the final say. Now, we were talking about this a little bit, and I had mentioned to you that you can, if you're the president, nominate, and then Senate, they can appoint new justices, and you can impact how the court works. I mentioned to you that the Congress, the House and the Senate together, can actually set the membership. So if they don't want a president to make an appointment, they can actually lower the membership, or in theory, they could actually raise the membership too. Either way on this. The other thing that they can actually do is amend the Constitution. And see, think about it. If you want to amend the Constitution, you're basically going to need 3/4 of the states to agree. However, if you want the Supreme Court to do this, you really only need 5 yes votes as opposed to 38 states, and it's far easier to go to the court in order to get them to establish something. It's really hard to amend the Constitution to change what the court did. The other thing up here is choosing a case. And you notice up here it says the rule of 4 specifies that if 4 justices vote to hear a case, it will be placed on the docket. Think about that for a second. It's really hard for 4 justices to agree, so it's really hard to get on the Supreme Court docket. And you notice up here it says, has the court been ruled on in a contradictory manner? Is the constitutional matter of national importance? Think about it like this. If a court in Texas says yes to that thing that we were talking about requiring you to join a union, but a court in New York says no, well, that's a contradictory ruling, and they would be more likely to want to get one national statement of law. So that's typically the place where it goes. Is it a constitutional matter of national importance? Well, you know, think about it. The presidential election with Bush and Gore kind of got expedited up to the Supreme Court. That was a matter of national importance, so that's what we're talking about. Give you one other thing on this one, and you notice up here it says time crunch. The way that it works when you go before the Supreme Court is each side is basically going to get 30 minutes. You get 30 minutes before the court in order to be able to make your case as far as whether something is legal or whether it isn't. And the beauty of this, or the trick with this, is the justices can pepper you with questions while you make your argument. So you don't just get up there and have 30 minutes, but there's stuff going on. They're asking you questions, and you can kind of tell sometimes if a justice is in favor of your argument based upon the questions asked, or you can kind of tell if the justice is against. This is why I think it would be kind of cool to take y'all in for a few minutes to see the Supreme Court, and I was hoping we could really do that today, because you would get to see how the justices are almost talking to each other when they're asking questions, but that's what oral argument is. Y'all got any questions about this?
How long does it take before the Supreme Court hears your case?
You know, let's put it like this. It's going to have to go up through the legal system. And a safe thing to say is it's probably going to take about 2 years, maybe at minimum, to get to the Supreme Court. And then the term for the Supreme Court basically goes from 10 to 6, meaning it starts in October and it ends in June. So oftentimes they will hear cases October, November, January, and then they'll release their opinions in May and June. And oftentimes they save the biggest opinions for the very end, so they'll be the last things that would get announced. So it would take basically a term to get a decision, but it would take several years to get to the point where your case could get argued. Make sense? Anybody with anything else? Let's hustle down. Here's another one up here that I wanted to hit on, and this is now we're starting to get into the FDR years, and you'll notice up here 15 justices. I don't know if y'all had ever heard about this, but when FDR was elected president, FDR was doing a lot of things, particularly economically, that had never been done in the country before. And you remember when I had said to you that because justices are appointed by presidents sometimes several decades in the past, that these justices might have mindsets that are a little bit behind? Well, basically, the justices that were on the court began to strike down a lot of his legislation. And you notice up here, he came up with this court packing plan. Roosevelt proposed to increase the number of justices. So if there was a justice on the court that was 70 years of age or older, he said, I'm going to appoint a new justice to basically help ease the workload, get some new blood in the court, this kind of a thing. So think about it. He was losing cases 6-3. There were 4 staunch conservatives, there were 3 liberals, and then there were 2 swings, and the swings would typically vote with the conservatives. So his thought was, if I'm losing 6-3, if I appoint 6 new members, now I'm going to win 9-6. Well, the country didn't take very lightly to this, and of course he was packing the court, and if he did this, then you think the next president coming in, they would pack the court. Pretty soon we got a Congress instead of a Supreme Court. You get the idea. So it turns out that this is where the phrase, the switch in time that saves 9, was coined, because those 2 swing justices, instead of voting with the conservatives, began to vote with the 3 liberals. So instead of, what's that?
They just decided to vote.
Just decided to vote, the switch in time. So they began to vote with the liberals, and instead of losing 6-3, he started to win 5-4. So kind of keep those thoughts in mind. And then one of the justices retired, and he appointed a 6th liberal, so he began to win 6-3. And they say that the court is supposed to be insulated from public opinion because they get lifetime appointments. This would be one of those examples. An immensely popular president challenged them, and a couple of them wavered just enough so that ultimately FDR began to get a number of legislative pieces through. Let's go ahead down, I think, to the last one down here. You notice up here, this is from the 1953 to 2005. This is really almost the modern time when you put it into context. And you'll see a couple of things up here. Number one, you'll notice up here this idea of conference. And we started to talk about conference before. Basically what the court does is they'll have a couple of weeks where they hear cases. So they're actually hearing cases fairly regularly, the oral arguments like we talked about. And then they'll take a couple of weeks when they're going to be in conference. In other words, they're actually sitting down behind closed doors and they're discussing the cases that they heard. Now, when you look at this, and you notice it says up here, only the justices are allowed in the room. The junior justice acts as the doorkeeper. So if anybody wants to send in information or messages or whatnot, only the junior justice answers the door and passes it on to the people that are actually within the conference room. And this is the justices where they actually talk. And this is where I was saying before, where the Chief Justice would speak first. Everybody speaks at least once, and then ultimately they vote. And they do this in order of seniority. So the Chief Justice speaks first, and then it's high to low. And then again, when they vote with the lowest seniority up to high, with the 9th vote being the Chief Justice, even if the Chief Justice isn't the senior member. The other thing up here, and maybe y'all have heard of Brown versus Board of Education. This was the case that ultimately struck down segregated schools in the country. And Brown versus Board of Education is a big one. I'm sure at some point you may do some reading on this. The arm twisting behind the scenes is probably more important than some of the things that happened in open court, because this was such a controversial issue. They really wanted it to be 9-0. They really wanted it to be 9-0. And you think about it, if it's 5-4, that means it could get changed really quick. If it's 6-3, that's better, but it's not that good. And even 7-2 and 8-1, there's going to be a dissenting opinion that become the seeds of the next case. Well, it's funny because Chief Justice Earl Warren was actually the governor of California when we talked about the Korematsu case. Y'all remember that? The Japanese Americans getting locked up. And it's funny because if you look back at the Korematsu case, Chief Justice Warren was the California governor, and he felt horrible about the fact that this happened in his state. And if you read that case, the very first lines of it were, anytime a classification is based primarily on race, it is immediately constitutionally suspect. Well, then they said, but in this instance, Japanese Americans, you need to serve your role just like women working in the factory, soldiers fighting overseas. Well, when Warren became Chief Justice, he started off, he was the person that wrote Brown versus Board of Education. And his language to start off this case was, anytime a classification is based primarily on race, it is immediately constitutionally suspect. In other words, he used the exact same language that was used in Korematsu. Korematsu had a but. This time he didn't have it. And he felt like he was undoing some of the guilt that he had as a governor in California with the Korematsu case when he wrote this one. And remember, they arm twisted an awful lot. They wrote it very carefully to get to 9-0 because they didn't want there to be any doubt, no doubt that in fact this was the law that the country was supposed to have. Does anybody have any questions about any of these?
Was there like a new era because of the sentence in 2005?
You know, if you look at it now and you think about it, we mentioned Justice Rehnquist had passed, and we were talking about W's appointments before. You look at it now, and there have been a number of new members that are on the court right now. So there are a lot of people, there are some that have been there for decades, but you figure Obama appointed several, George W. appointed several, Trump has already appointed one. That's a majority right there. Yeah. So yeah, you could argue.
And do the majority of them go until they retire, or they actually go until death?
It depends. I mean, Rehnquist, he died unexpectedly. Justice O'Connor retired. There are usually some hints. Around the corner, Thurgood Marshall's portrait is posted.